Interesting development there in the War Machine case, as we just heard. That's a case that we covered very closely about this time last year here on the Law and Crime Network. Joining us this afternoon, Saam Zangeneh is with us. He's going to talk about the War Machine case a little bit and also about the Price case that we're continuing to take a look at here in Law and Crime. So, Saam, good to see you this afternoon.
Hey, thank you for having me. I appreciate coming back.
What do you make of this War Machine case? I mean, we covered it very closely here on the Law and Crime Network when it was going on, and now you've got this prison pen pal talking about getting hitched, I guess, with War Machine. What do you make of this?
Well, I'll tell you, this isn't the first time I've had a situation where I've heard of convicted murderers or convicted felons developing a romantic relationship while they're in custody and eventually getting married. I've had a few clients of my own that have done something like that. So it's not uncommon. But it's a very uncommon situation.
Okay, so not uncommon, but what goes on in the minds of people? What do you advise a client who's approached by a pen pal and then some kind of romantic relationship ensues? What do you tell the client who's incarcerated? Or is this just completely beyond attorney-client discussions?
Well, listen, these are just like the War Machine, gentlemen. A lot of these people that develop these relationships have life sentences or really, really long sentences. So what are you going to tell your client? Not have somebody that writes you letters and calls you and wants to spend time with you and makes you feel special? Yeah, it's their life, and even though they're living it in kind of a confined manner, they try to make something positive out of it. So whatever you can make positive out of a difficult situation, which I guarantee you this is, you want to kind of promote that kind of stuff.
Okay, and the law generally allows this, okay? The presumption being that if a prisoner is allowed to sort of create some family ties, then it might help rehabilitate the person who's incarcerated, and therefore they might behave better when they're behind bars. They might have a support system if and when they're released, correct?
Yeah, absolutely. And this crime happened in Nevada, and Nevada has a parole system. So I'm not exactly sure. I don't recall when he's eligible for parole. But if he does develop a relationship with someone that has familial ties, and he's able to show the parole board that when he gets out, he has a new life with a new love interest, somebody other than the purported victim in this case, and that he wants to start kind of fresh, I think that that's going to be something that will be advantageous for him when he does talk to the parole board, if that occurs.
Exactly. Well, we're going to continue to keep an eye on the War Machine developments. If and when there are indeed wedding bells chiming in the air, I'm sure we'll be talking about that if indeed that happens. In the meantime, we're going to dial back to the Jonathan Price case. This is the case of a U.S. Marine who was killed at age 26 while he was in the parking lot of a bar waiting for friends to arrive for a birthday celebration for that corporal's wife, Megan. She testified during the case against Dawan Mulazim and Quincinio Canada. Those are the two defendants accused of committing this crime. But as we've been talking about here on the Law and Crime Network, there are issues with identifications. There are issues with whether or not the identifications made by some other victims were racially stilted with some racial undertones that call those identifications into serious question from an accuracy standpoint, and also issues about the gun that was identified by Megan Price. She survived the shooting with a shot to the leg. She said the gun was silver. The gun that authorities believe was used in this attack was completely black. Is it a misidentification? How's the jury going to interpret it? Those are the big questions. We're going to continue to listen to testimony now. David Richardson is a cell phone and video analyst. He was on the witness stand in this case. Let's listen to his testimony. Welcome back, everybody. We are continuing to break down testimony in the Jonathan Price murder trial. He was a U.S. Marine corporal shot and killed at age 26 while he was out to celebrate his wife's birthday. Saam Zangeneh is still with us here on the Law and Crime Network. Saam, we want to talk about some of the testimony we just saw. We have some law enforcement officials saying that the defendants' vehicles were in the area. They're trying to place their phones in the area. So which is it? Is this evidence that these guys committed this crime, or is this just evidence that they were in the wrong place at the wrong time?
All it is that it's evidence that they were in the area. That's all. That's all the tangible evidence can show. Now, what a prosecutor will do is that they will use the fact that they can attempt to use forensic evidence, tangible evidence, to show that they were at the scene. And by putting them at the scene, it assists the prosecution in trying to prove that these guys are guilty beyond a reasonable doubt, because obviously there's a substantial amount of problems with some of these identification issues, some of the racially charged statements that were made by these additional witnesses, the misidentification of the firearm. So the prosecutor really needs to be able to kind of sink their teeth in proving that these gentlemen were at the scene. Okay? Now,
exactly.
Okay. So I'll tell you this. I currently have the Dan Martell murder case in Tallahassee. That's the FSU law professor who the prosecution's theory was that his wife ordered two hitmen from Miami to come up and commit this murder. And we have been dealing with cell tower evidence in that case. And what I've learned through this part of my career is that the cell tower evidence can only show that they were in a specific portion. It's not that it's not like what you think that they can tell you the exact location. They can only give you a general area between the towers, because that's what they do. They send images and messages off these towers, and then based on the towers, they can make a guesstimate as to where they believe that these people were in roughly that same period of time.
Yeah, exactly. So here we're trying to we've got them in the area of the tower, but it's not a precise GPS plot on the point. And that's where we're at. So we're going to listen to a little bit more testimony now from David Richardson. He's reviewing the security camera footage. He talked a little bit about the cell towers. Let's listen to a little bit more of his testimony. Okay, so exactly what was going on when those cars were seen coming and going from the parking lots. And what's up with the difference between the gun? Is it a silver gun, as the surviving victim said, or is it a black gun like the authorities recovered and argued was the murder weapon? A lot of discrepancies in this case for jurors to try to make sense of. Saam Zangeneh is still with us here on the Law and Crime Network. So, Saam, I'll ask you the question, how do jurors try to ferret the truth out of a case like this where there are a couple different sides, circumstantial evidence, and unclear witness identifications? Okay.
So before I start, I got to tell you, I have to comment on the fact that that opening argument sounded like a closing argument. And the fact that the prosecution wasn't jumping up and down and making an argument kind of put me in a state where you got to question what's going on over there. But listen,
how so? Well, let's deconstruct that then. So how so? I mean, are you saying that there was too much argument in the opening statement?
It was 100% argument. All of her statements were conclusory. The opening statement is to show what the evidence is going to show. She sounded like she was doing a closing argument there. I don't know. Maybe it's just me. But, when I was a prosecutor, which I was here in Miami for 3 years, I would have been jumping up and down saying that she's making argument as opposed to presenting an opening. Right? I mean, because that's what she was doing. She was saying this is what the evidence is and this is what it's going to show. But that, I don't know. Maybe that's just me.
Well, different jurisdictions are a little bit different with this. I mean, this is Lexington, Kentucky we're talking about, and rules are different from state to state, and oftentimes that's where the differences are in these cases that we observe here on Law and Crime. So, look, we are going to take a quick break here on Law and Crime. We're going to be back with more analysis in the Jonathan Price murder case when we come back. Stick around. It'll just be a couple minutes. Testimony there about gunshot residue in the Jonathan Price murder case out of Lexington, Kentucky, where two men, Quincinio Canada and Dawan Mulazim, are accused of shooting and killing that U.S. Marine corporal at age 26, and also shooting and injuring that corporal's wife as the two were outside of a bar to celebrate her birthday. Saam Zangeneh is still here with us on the Law and Crime Network. So, Saam, let's talk about this gunshot residue. They're trying to figure out, how close the weapon was to the shirt and everything. In a case like this, where you've got conflicting identifications and questionable identifications, how much is the gunshot residue really going to play into the prosecution's case?
Well, I mean, listen, let me ask this question. Whose shirt is that?
It was Jonathan, so that's the victim's.
Right, so yeah, he got shot. And let me tell you, gunshot residue matters when it's on the defendant. I mean, we know that Mr. Price was shot and he was tragically killed, but there's no question that he was shot. The question is who shot him. So if you're able to get a piece of clothing from either one of the defendants that has gunshot residue on it, then there's evidence. But without it, it's a waste of time. So what? Yeah, we understand this guy was shot. We're not there. I'm sure they're not disputing that he got shot and killed. The question is, who did it?
So
now,
if you were back in your prosecution days, would you not have even put that in, or would you have put it in to try to somehow bolster your case as being more thorough than not thorough?
I mean, listen, it all depends on what the jury looks like, okay? No matter what happens in a case, real trial lawyers, they make the determination. You pull the plug on what you think that jury that you have in front of you. The 6 or 12 people that are going to ultimately make a decision as to your client's innocence or guilt. So if I'm a prosecutor, I read the jury. If this is the kind of jury that I believe is going to want me to be as thorough as possible, then I put it out there. And then also you have to take into account who the defense attorney is, because that evidence to me doesn't produce anything.
Yeah, well, the bottom line is they did put it in. So look, we're going to take another quick break here on Law and Crime. We'll be back with more testimony in the murder of Jonathan Price when we come back in just a few moments. Jessica Hansford back on the witness stand, listening to her own 911 call from when she was staying overnight in a Lexington area hotel, and she was robbed along with a number of other people. Prosecutors played that call in the Jonathan Price murder case because they believe that the weapon stolen from a number of people in that hotel was the weapon used to kill Jonathan Price. Saam Zangeneh is still with us here on Law and Crime. Saam, I want to ask you a question about how far prosecutors can go in bringing in this evidence of other crimes into a trial about a different crime, because in a lot of states, prosecutors just can't go that far. They might be able to say, hey, look, we recovered a weapon from this other crime, but to bring all of this emotional 911 recording information and whatnot into this murder case, does that cross a line?
Well, like you said earlier, different states have different rules. But what I know about the state that I'm from, which is Florida, is that if you want to bring in similar act evidence, you have to do it through a mechanism or a vehicle called Williams Rule, where you have to show and you have to satisfy several legal prongs. One of the prongs being that the crime has to be inextricably intertwined with the other crime to show that there's a nexus that's more important than the potential prejudice on the defendant. This case has so many like double-edged swords in terms of evidentiary value. They're trying to bring in the robbery of a black firearm, where the victim, who was unable to identify the accused in this case, the surviving victim, indicated that the firearm was a different colored firearm. So, I think it hurts the prosecution's case to bring this in. I think that they're trying to stack as much evidence as they can, to take as much time as they can to try to bring in evidence, which really, to me, doesn't carry that much value. What do you think?
Well, I think along similar lines, but look, it goes back to they needed the identification from the hotel robbery to try to point the finger at these two defendants, that is Quincinio Canada and Dawan Mulazim, and they needed that because they didn't have a good identification from the scene. So you've got some kind of an identification from the hotel room suspects, but we know one of them was making racist comments on Facebook, and he was attacked about that. So how good was the hotel room identification? I'm just glad that I'm not the one that has to decide. Ultimately, I can point to the issues, but the jury's job is to decide. So as we move along in our review of testimony here in the Jonathan Price murder case, we're going to listen now to Debbie Price. She is the victim's mother, and she was on the stand testifying about her son. All right, welcome back, everybody. We are about ready to enter the closing arguments in the Quincinio Canada and Dawan Mulazim murder case out of Lexington, Kentucky. They were accused of killing U.S. Marine Corporal Jonathan Price, 26 years old, as Price and his wife Megan were out at a bar waiting for friends to arrive to celebrate Megan's birthday. It was supposed to be a celebration. It ended with Jonathan Price dying right there in the parking lot of that bar. Saam Zangeneh is still with us here on the Law and Crime Network to talk about this case a little bit. So, Saam, going into closing arguments here, what does the defense really have to hit on?
I mean, listen, there's a lot of problems for the prosecution's case. The identification issue, I think, is the biggest button for a defense attorney to push. That's what I would be pushing, and I'd be pushing it hard. Because but for a collateral crime, which actually I think helps the defense, and some cell tower evidence, you've got a very weak prosecutorial case. And the worst part about it, this is a tragedy. You have an innocent man, a hero, a man that had put his life on the line for our country, gunned down in a kind of like nonsensical way. And so you want to have justice for him, but you want to make sure that you have the right person that gives up their lives for the life that was taken. So as a defense attorney, I would hammer home that there's no forensic evidence, that there's the identification issues are a big deal, especially with his wife, the corporal's wife, not being able to identify the shooters. That's a big problem.
Yeah, these are all issues, but I got to ask you another question. You've sat on both sides of the aisle here. You've been a prosecutor. You're a defense attorney now. How do you handle it in front of the jury when you're up there for the defense and you have a highly sympathetic victim and you have a victim's young wife who's also a highly sympathetic victim on the stand? How does a defense attorney get up there with eyes on him or her and try to cut through that?
I think what you have to do is you have to show that you're also sympathetic for the loss of this individual. You have to show that there's a human side to you, because a lot of times defense attorneys we're portrayed as being subhuman. And so a way to attack a case like this is to really go in and humanize the victim, because I'll tell you, the prosecution is going to do that ad nauseum. And so when you go in and you kind of parrot along the same lines, that this is a hero whose life was snuffed out in a unbelievably tragic way, and there are people out there that took this person's life, but it's not these people. It's not these two people. And not only is it not these two people, but the prosecution has a burden to show that these people are guilty beyond a reasonable doubt.
Exactly, that he's the kind of guy who donned a uniform and took an oath to defend the country to make sure that we have justice in our courts, and perhaps that link could be made as well. Well, we're going to listen to the defense closing arguments for Quincinio Canada. Remember, two defendants, each has his own attorney. Quincinio Canada's attorneys went first. Those are some of the closing arguments for the attorney for Quincinio Canada in the Jonathan Price murder case out of Lexington, Kentucky. Saam Zangeneh is still here with us on the Law and Crime Network. So, Saam, I want to ask you real quick, right off the bat there in our look back at this case, the defense is saying, look, they had a photo of Quincinio Canada, this attorney's client, and it was altered to remove tattoos. And I remember when this case was going on, there was a big back and forth here about whether or not they had to remove them or whether they shouldn't have removed them, because a lot of people say they have to be removed to make, because otherwise, if you remember, let's say you're a victim of a crime, you would remember a tattoo being on somebody and you would automatically pick out the guy that had the tattoo, whether it was the actual attacker. So what's your thoughts on that? Should the photo have been altered? Should it not have been altered?
No, of course it shouldn't have been altered. I mean, listen, tattoos are identifying markers on people. And so, you know, if somebody's got a butterfly tattoo on their neck, and they make a statement to law enforcement that my attacker had a butterfly tattoo on their neck, and then they pick somebody out of a photo lineup that's the same person, I mean, it's something people use to guide themselves. More importantly, when you alter evidence, a competent defense attorney will make a big deal out of it. And I you know, to be candid, I don't know who this defense attorney is, but I would have made I would have made a huge spectacle of this whole thing. You know, I would have gone on a huge rant about how they had issues with identification and that it got so bad that the detectives had to alter the photograph to assist in making the identification.
Yeah, you know, I had the same complaint about some of the defense tactics in this case as well, Saam. So it's interesting that you point that out. And look, the defense attorneys know their local audience. They are looking at the jurors, and if the jurors are buying what they're selling, maybe they don't have to make a big spectacle about it. But also, when the racially charged Facebook posts were found from the hotel robbery victim. I thought they should have made a bigger deal about that. But we're going to take a quick break. We're going to be back with more closing arguments in just a minute. Welcome back yet again, everybody. We're talking about the Jonathan Price murder case in Lexington, Kentucky, the case of a 26-year-old U.S. Marine corporal who was shot and killed outside of a bar while waiting for friends to arrive to celebrate his wife's birthday. The wife was also injured in the attack. Saam Zangeneh is still with us here on Law and Crime. We were talking before the break, Saam, about trial advocacy, okay? You know, and my trial advocacy professor taught me that when you're a defense attorney, or when you're a prosecutor, if you've got like one of the key pieces of evidence, you make that last forever. You find every single way to describe it. You treat it like it's a Rubik's Cube or whatever. You know, you keep turning it around. You keep making the jurors look at it from a different angle. Even if it's just a little one-sentence piece of information, one fact can be viewed from so many angles, and you think that the defense fell down in this case.
I mean, I was watching the closing argument and I was thinking to myself, when is this guy going to turn it on? When is that passion button going to get pushed? And it didn't. I mean, listen, this guy was up there walking around with a piece of paper, shuffling it back and forth, didn't appear to be focused, didn't really have the kind of drive that you would think that a defense attorney would have, and the energy about about the shocking problems of the prosecution's case. This guy... And what we were talking about during the break was that, you know, there was an identification issue from, I believe, one of the other witnesses where they had made some very inappropriate comments on social media, which had a direct correlation to the race of the accused. And during the trial, this guy just tapped on it, where I believe, you know, you and me would have sat there with a baseball bat and beat it to death and beyond.
Exactly. I mean, exactly.
This kid, listen, and you know, we talked about you understand that you have to understand the jury that you're dealing with, and so on and so forth. But brother, you know, regardless of where you are, passion matters, and being pragmatic matters. Those are big deals, and you have to be able to fight through them. And it seemed like this guy was kind of tiptoeing around some stuff that he should have been jumping up and down about.
Yeah, you know, I don't disagree with your analysis. Look, we're going to switch gears now and talk about the closing argument from Dawan Mulazim's attorneys. Again, keep in mind, two defendants, two different sets of defense attorneys. This is the closing for Dawan Mulazim. That was a defense attorney for Dawan Mulazim, one of the two defendants accused of shooting and killing 26-year-old Marine Corporal Jonathan Price in Lexington, Kentucky. Saam Zangeneh is still with us here on the Law and Crime Network to help break this case down. I really like the way that attorney sort of gave a clear roadmap at the beginning of the case. She wasn't bombastic, but she was logical. She hit all of the bases. Bam, 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 bam. These are all the problems with the state's case. Saam, what do you think?
I 100% agree with you. I got to tell you, it looked like she had some sort of audio visual that she was referring to, as opposed to having loose papers in her hand. She was organized. She hit on the most important parts, the identification issues, she took what the initial defense attorney for the co-defendant was trying to argue, and I believe articulated it in a much more suggestible fashion. I thought she did a very, very good job. She was a little bit stoic, but organized, and she made the point that she was trying to make. Yeah. I think she did a much better job than the court.
I think she was focused on making a logical argument. And of course, look, it's a double-edged sword when you're a defense attorney, because you don't want to say things that are going to come across to jurors who might be inclined to convict as being attacking their viewpoint either. So that's why defense work, I think, oftentimes is a double-edged sword, because if a defense attorney kind of gets too bombastic, it can really turn the jurors off.
Well, listen, like you said earlier, you have to understand the jury that you're in front of and the pond that you're swimming in. There's two ways to kind of look at this in my view. And based on a lot of the inconsistencies in this case, the lack of evidence, and the way that the prosecution, most importantly law enforcement, attempted to kind of put a square peg in a round hole in this case, I'm the kind of person, my persona, I would be colorful.
Yeah, I can certainly understand that. Yeah, we're going to have to take another quick break here on Law and Crime, Sam, so stick around with us. We're going to be back in just a few minutes. Again, we're talking about the Jonathan Price murder case. We're going to hear from the prosecution in just a moment. And welcome back to Law and Crime, everyone. We are about ready to listen to the prosecution's closing arguments in brief in the Jonathan Price murder case out of Lexington, Kentucky. Two defendants, Quincencio Canada, Dawan Mulazim, accused of shooting that 26-year-old U.S. Marine corporal and also shooting and injuring his wife, Megan, outside of a bar. Saam Zangeneh is still with us here on Law and Crime. We're going to talk real quick about what we expect to hear from the prosecution. So, Saam, what do you think? What does the prosecution need to do to try to seal this up, given the issues with the case?
I mean, they're going to have to pull at the heartstrings of the jury based on the fact that a war hero lost his life, and use the circumstantial case that they have, leaving out the snippets of how the circumstantial case was put together, and really kind of hope that a jury comes back and says the fact that they have some evidence and a lot of holes in the others is going to be enough. It's a tough job for the prosecutor in this case. And, you know, as a former prosecutor, when you're dealing with homicides and you're dealing with next of kins, you do whatever you can to get a conviction. And, you know, I'm interested to see how the prosecution's closing argument goes.
Well, we're going to move into that right now. Again, prosecution closing arguments in the Jonathan Price murder case out of Lexington, Kentucky, where that 26-year-old U.S. Marine corporal was shot and killed, and his wife, who also testified, was shot and injured. And again, we're looking back at the Jonathan Price murder case out of Lexington, Kentucky, and Saam Zangeneh is here with us on Law and Crime. And Saam, in the beginning of that clip, at least, the prosecutor was kind of going through this blow-by-blow reenactment of what was going on in the hotel robbery 2 weeks before the murder. It sounded like she was trying to spend a lot of time rehabilitating the witnesses to that robbery because, of course, we know one of them was making racially insensitive comments on Facebook about the people who committed the robbery at the hotel, who were allegedly these two. So what did you make of the way the prosecutor was sort of going through the motions of that argument?
Well, it sounded like me like she was attempting to rehabilitate a lot of things there, as opposed to making her points on what the evidence shows and how the evidence, how the prosecution has proved their case beyond a reasonable doubt. It sounded like the prosecutor was doing a lot of explaining, minimizing, kind of passing the buck on the defense's theories and points, and she kind of lost track on really focusing on what mattered, which was the homicide. You know, she had a very difficult case to move forward with. She had a very difficult case to try, and I think that she did her best in attempting to sway the jury. Look, when she was trying to focus on the robbery, it's to create a sense of they did this over here, and then they're likely to do it over here, okay?
Exactly,
yeah. That's what he's trying to do. He was guilty for this, so he's probably guilty for this, and I want you to take into account his previous act and take it into consideration here.
Trying to tie the two together, exactly. We have to take another quick break here on Law and Crime, so we're going to do that. We're going to be back with a little bit more of the prosecution closing argument when we return here on the Law and Crime Network. We are just about to listen to the prosecution closing argument, a little bit more of it, I should say, in the Jonathan Price murder case from Lexington, Kentucky. But we're going to talk a little bit more about our perspectives on exactly what was going on in the first part of the prosecution argument. And for that, Saam Zangeneh is still back with us on the Law and Crime Network for a little bit more. So, Saam, what do you make of the way the prosecutor was trying to tie all this together in a case with faulty identifications, issues with whether or not the weapon noticed by the victim is the weapon that police believe was involved in the case?
Well, listen, she has a lot of problems. And so when you have a lot of problems, you got to hang your hat on what you got. And what she's got is an allegation that these two black men were involved in a robbery a few weeks before. And when you have an allegation of a previous crime of violence, it's easier for a juror to accept that they committed another act of violence. And having a firearm, whether or not it was misidentified as black or silver, which is substantial, the prosecution's still going to try to hang her hat on the fact that the gun was stolen in a violent crime and they subsequently used it to kill this war hero. I mean, it's an uphill battle to say the least, but that's what I think she's trying to do.
Yeah, okay, so we're going to listen to a little bit more of the prosecution closing argument, and then it'll be time for the verdict here on Law and Crime. So, as it came to Quincinio, candidate not guilty on any charge related to the attack on Megan and Jonathan Price in that bar, but guilty as to the Quality Inn robbery, which happened 2 weeks before. I'm here with Saam Zangeneh. He's been tracking this case along with us. And look, we know that this happened in the past, but this was a split verdict. They believed the witnesses in the hotel. They didn't think there was enough evidence there for the attack on the Prices.
They split the baby. That's what they did. They split the baby. The evidence, in my estimation, was unconvictable with regards to the homicide. I thought the robbery was weak, to say the least. But I think that they wanted to convict of something. And since they weren't able to convict on the homicide, they used a collateral avenue to convict on the Quality Inn robbery.
Well, that could be one way through it, certainly. We're certainly, if you haven't followed this case, folks, you're going to want to hear the verdict now for the other defendant, Dawan Mulazim. We're going to listen to that one now. Wow, an interesting verdict there for the second defendant, Dawan Mulazim, hung on all of the counts related to the Prices, guilty as to tampering with evidence, guilty as to the hotel room robbery. So, Saam Zangeneh, this is the same jury that acquitted the co-defendant, but they couldn't decide unanimously on the top charges here.
Yeah, I mean, that's kind of a shock, yeah. Usually in scenarios like this, if the prosecution proves or is unable to prove the case against a co-defendant, a jury usually follows in kind. Really kind of an unusual scenario here, but it's in the books already. So what can you do? Yeah, exactly. Okay, so bottom line, you've got a conviction on the hotel robbery charges, and those are actually pretty stiff penalties in Kentucky where this happened. So right. This is not going to be like a couple years. This is a long prison sentence. But it's certainly strange when you've got a split verdict like this. But if I'm remembering the minute details of the evidence, one was alleged to have been a lot more involved than the other. One was accused of firing the fatal shot, not the other. Could that possibly have been what the split was about? You know what? I thought about that too. But in the jury instructions, the judge read for the robberies that it included the principal theory, which means that even if you aren't the actual person committing the robbery, if you assist in any way, if you aid or abet, then you can be charged as a principal. So very interesting, to say the least. I'll tell you, if first-degree robbery probably carries a substantial sentence, especially since a firearm was involved. And so I'm not sure if the district attorney's office is going to want to relitigate this matter, because they're going to have the defendant serve a pretty substantial prison sentence. Yeah. Okay. Well, we're gonna have to think about this one for a while. We'll have to take the discussion off air though, because I want to bring something else up to folks. We have a getaway contest going on here on Law and Crime. We want to talk about this today. Enter to win. It's the ultimate true crime getaway. You get tickets to go to CrimeCon 2019. You get to meet Law and Crime founder, live PD host, ABC chief legal analyst Dan Abrams. Take a look at the setup here at the Law and Crime Network. Also, plenty of other good things. If you'd like to enter, go to lawandcrime.com. Click on the contest tab in the upper left-hand corner of the website. So do that before you forget about it. In the meantime, we're going to wrap up the broadcast today. Thanks a lot to Saam Zangeneh for being with us. I'm Aaron Keller. It's the end of the week. We'll see you back here with a new trial on Monday.